Good morning again. We are back on the record in the hearing as to public interviews for storm securitization financing order and docket number 2025-65E. All commissioners are present here in the hearing room. Gentlemen, you're here on behalf of Charles Rivers Associates. Before I go through the entire spiel that we did earlier, I was going to ask, did you hear our explanation about the hearing itself today when the Atkins, were you listening in at that time? All right. Well, then I certainly would like to review that. General Counsel Hill, if you would, please give a brief explanation.
Yes, sir. And gentlemen, whenever you speak, you've got a button down there that says push for your microphone because we are live streaming everything. So anyone who tunes in can hear it as well. There is only one item, as the chairman just mentioned, on today's agenda. It deals with the public interviews related to the responses to the solicitation that was made by the commission. On May 22nd, 2025, the commission instructed staff and Commission Order 2025-316 to issue a request for proposal for the selection of a qualified independent third party as required by Title 58, Chapter 27 of the South Carolina Code, and it relates to the petition filed by Duke Energy's Carolina in docket number 2025-65E. The term qualified independent third party means a person or entity with relevant experience in accounting, finance, and utility regulation sufficient to make the professional judgments as necessary to certify compliance required by Section 58-27, 1110, subsection C6A. The qualified independent third party shall be designated and retained by the Commission to participate in the pre-bond issuance review process established by the Commission as required by law and pursuant to its financing order. The role and responsibilities of the qualified independent third party are further detailed in Section 58-27, 110C6. The qualified independent third party's certification of compliance is intended to inform the Commission related to its financing order that it is in compliance with the law. On June 19, 2025, the Commission opened 5 proposals, including the one from Charles Rivers and Associates. There were others from Atkins Capital Strategies, LLC, Hilltop Securities, Inc., PFM Financial Advisors, LLC, and Sabre Partners, LLC, in response to the solicitation number 5400028374. And today, the Commission is conducting interviews related to those responses to the solicitations and with representatives from each of the individual entities. Mr. Chairman, the matter is ready to proceed with the instructions by you.
Thank you. Thank you very much, Ms. Wester Hill. Before we begin the interviews, I would remind the parties that a decision has not been made by the Commission in docket number 2025-65E, even though there was a settlement agreement presented by the parties of record. The record itself in that case is closed, so any discussion about that or what should be in that order would not be relevant at this time or proper. As Ms. Wester Hill stated, the purpose of these interviews is related to the 5 responses received by the Commission. By state law, the qualified independent third party designated must act in accordance with statutory obligations and any additional requirements established by a Commission order. The qualified independent third party must, 1, independently participate in the pre-bond issuance review process established by the Commission pursuant to Section 58-27-1110C2J. The qualified independent party 2 has the authority to request and receive all necessary documents, data, and information from the electrical utility to fulfill its responsibility and ensure compliance with Section 58-27-110C6A, and has the ability to communicate directly with the parties to the docket or the proceeding as needed by the qualified independent third party to carry out its duties. The qualified independent third party cannot communicate directly or indirectly with the Commission, any commissioners, or any member of the Commission staff. This to prevent any ex parte communication which is prohibited by South Carolina Code Section 58-3-260. The qualified independent third party designated by the commission must be able to work independently without involvement by the commission or its staff and be able to provide independently the conclusions as directed in the finance and order and applicable law. The qualified independent third party is limited and can only communicate with the commission in the docket only through the commission's docket management system with a file letter or document. Any other means is prohibited by law, including emails, telephone calls, text, or any communication not done through DMS or any other method otherwise available to all parties. The commission and its staff cannot talk or communicate with you except through orders or filings provided to all parties. All parties must have the opportunity to be in any meeting or conference, and all parties must have the same communications intended for one and provided for all at the same time. Just like the electrical utility and parties to this proceeding, the qualified independent third party makes any docket filing it believes necessary subject to and in accordance with the Commission's procedural rules and orders. The third party consultant may be subject to confidentiality agreements and prohibited from divulging sensitive information. The Commission has a process whereby confidential information can be provided and protected from public disclosure. The qualified independent third party is subject to the same process as utility and parties whereby confidential information can be provided and protected from public disclosure. The Commission may request the qualified independent third party participate in a post-pricing meeting, which will include the electrical utility, the qualified independent third party, and all other parties to the docket. Since I've explained and outlined the manner in which the qualified independent third party can communicate with the Commission staff, and that is only through communications filed in docket number 2025-65E, there is no need to further address ex parte communications. Gentlemen, welcome this morning, and we certainly appreciate you being here live from Boston, and would ask that you please introduce yourselves, give us whatever background you want to tell us about yourselves, and you can begin with any and all of your opening statements. You've answered our questions, so I'm not going to sit here and re-ask those questions. I know you're aware of it, but I would remind you this is being live screened, so anything about fees or monies I would not talk about, but that should be submitted through our procurement office. But the floor is yours.
Thank you, Mr. Chairman. For starters, my name is Matthew DeCourcy. I'm a vice president with Charles River, part of the energy practice.
I'm Brad Wendt, and I'm a senior consultant at Charles River Associates.
Could you both pull the microphones a little closer?
Yes.
Okay.
Is that better?
Thank you very much. You may proceed.
I'm Bradley Wendt. I'm a senior consultant at Charles River Associates.
All right, so.
So I would sort of be open to the commission's view on how best to proceed. We did submit the written answers to the questions. We have a presentation that gives us an overview of our qualifications at a pretty high level. We could walk through that, or if the commissioners have questions and you want to just go straight
towards that. Go
towards
ahead and give us a little background. We're familiar with you, but certainly for the record, go ahead and.
Okay. Is it possible to put the presentation up somewhere?
One second.
And I can add, one of our colleagues is on the Zoom call, and he could call it up, I think. Chris, if you're there and you're listening.
And that's Mr. Nagel.
That is Mr. Nagel.
All right. Mr. Nagel, you there?
I am here, and I will attempt to share it now.
All right.
And for the record, Mr. Nagel is a principal with our energy practice.
All right.
All right, we should be viewing the screen.
Chair Powers, for expediency's sake, would it be okay maybe if you just kind of got started?
Yeah. Yeah, certainly. Whenever the commission's ready, we are too. I can. Is there a way to advance it? So we addressed our presentation on answering what we think is the core question for this discussion. Why are we best equipped to serve as the qualified independent advisor? It's a quick walkthrough of our qualifications, our capabilities. There's a lot of slides. I'm not going to belabor them. I would encourage the commissioners to stop us, to interrupt, to ask any questions that may come up, and we can dive into detail in any area as we go along. So our core value proposition, and the reason why we think a firm like Charles River is best equipped to do this work, is that securitization is incredibly complex, and it requires kind of two simultaneous elements of utility regulation and corporate finance. The advisor is going to be asked ultimately to compare the all-in cost to customers of financing by a securitization versus traditional rate making, which requires a deep understanding of both sides, traditional rate making. And then also to comment and opine on the process by which the bonds are issued and marketed and underwritten, which is a whole other area of specialization and deep expertise. We're able to bring both of those capabilities to bear in a comprehensive package supported with lots and lots of analytical horsepower and resources from a large firm. I'm part of our energy practice, which makes me the regulatory guy in this context. I've spent my career on utility rate making, utility finance, utility strategy. I've appeared before commissions in rate cases and docketed proceedings about rate making. Prior to joining Charles River, I was the vice president for regulatory for a utility holding company. Brad joins us from our finance practice, where he has extensive experience on the nuts and bolts of issuing debt, valuing debt, and I'll let him talk through his qualifications momentarily.
Let me interrupt you for 1 second.
Yeah,
I
please.
apologize for that.
No?
Your handout is marked as private and confidential. If there's certain things there that you do not want to share, please be sure and.
No, we were alerted to that. That's fine. We can waive
Okay.
all of that.
Just wanted to make sure. Thank
No,
you.
thank you. I appreciate it. So we think we bring both sides of that in a comprehensive package, and we think that's the reason why we're well qualified to take this on. We recognize that our background is probably different from some or most of your other proponents. We have not done much work reviewing these kinds of transactions, but we've done a great deal of work executing these transactions from the inside. So I think we have deep insight into all aspects of how this works in general, how this works in South Carolina, and a lot of expertise to bear from that perspective.
Can you explain what you just said
Yes,
to me
please.
a little bit, where you said we have not had much experience reviewing, but we've had experience executing?
Yeah.
Can you elaborate on that a little
Sure.
bit?
So I have been an executive at utilities that have issued securitized debt. I've been part of the team that's from I guess in this case, the analog would be from Duke's perspective, going out to the market and doing the things from the utility side on the debt beginning to end. Brad has done the work that the underwriters are doing and that some of the other financial analysts are doing. So we have been deeply involved with these kinds of transactions as the proponents of them, or whatever you want to call it, but less so with sort of review of others' transactions.
So the process of shopping the bonds on the market is not something that would be new to y'all?
I can answer that. I have spent the last 30 years of my career in fixed income, which, as you're probably well aware, is just a fancy name for bonds, but they refer to it as the fixed income department. And I have been involved with over $100 billion of issuance, hands-on issuance over that time period. Some at a senior management level, but I actually started my career as a energy banker at Merrill Lynch Capital Markets upon graduating from business school. So yes,
That's what I was looking for. Yes, thank you.
Yes, it is a yes.
It's fair to say, I don't think there are a ton of people who have more experience with shopping bonds than does Brad. So maybe we can flip ahead to slide 7 when you have it. And so really, our value proposition is that comprehensive package of the insight on the utility side, the insight on the regulatory side, and the insight on the financial side. That's perfect. Thank you very much. And so I'm going to lead us off and just talk a little bit about some of our capabilities on that regulatory rate-making side. Charles River has worked on regulatory matters and rate-making matters with utilities on all the aspects of the rate-making that will underlie the securitization. So we members of our team, as in past roles and current roles as a firm now, we've worked on securitization. We've worked on alternative rate-making for costs like securitization. We've done a lot of work with the nuts and bolts of utility debt, utility capitalization, utility debt issuances. And we, as a general matter, have pretty much covered the waterfront on the kinds of issues that go into utility rates, and we spend a lot of time in commission proceedings just like this one. We've pulled out a few simple examples that I think highlight this. A few years ago, when Empire District Electric, a Missouri utility, retired a coal asset and incurred some large storm costs during Winter Storm Uri, they securitized $300 million. That, at the time, this is one that I ran. I was responsible for all aspects of this from the utility side, between interaction with the bankers, between selecting the bankers, between appearing at the commissions where Empire does business. Over the course of about 18 months, we went through the entire process, and we were the first to do so in Missouri under new legislation. And in early 2024, we issued $300 million worth of debt. The project, I think, was pretty unambiguously a success. Question, sir?
Mr. DeCoursey, Chair, if I may ask.
Go ahead.
One, if you could pull that mic a little closer, that would
sorry.
help. I'm following you, but I'm having a strain. The other, as I hear that and kind of looking through the stuff, clearly sounds like the company has a lot of experience. You do, primarily from the utility perspective, relative to, say, serving in a similar role. So with what this statute relative to the commission would be, have you served or do you have any experience in that role specifically on behalf of, say, a regulatory commission?
As the independent advisor.
Yes.
Not for securitizations. So we do serve as the independent advisor for other things overseen by the regulators. We're involved with utility procurements and some elements of IRPs where we're selecting things and validating the conclusions independently on behalf of the commission and its staff, but not on securitization. We have, in the course of the work we've done, undertaken what is essentially the same scope, at least analytically, insofar as the utilities and rules vary by jurisdiction, but one way, shape, or form, the utilities are required to calculate net benefits and demonstrate them to the regulator to demonstrate that there are benefits in the way the bonds are being marketed. So we've undertaken the work, but we haven't done a certification letter to that effect.
How would you envision, or how, relative to, say, staff or folks that, have performed this type work with the Duke companies, how would you establish that firewall or distinction, I guess, to make sure or avoid any potential, conflict?
Yeah, it's a good question. It's a fair question. I think we would lean heavily on the I in independent. Our view would be we are conducting our own analysis and our own review in parallel with the work that the utility is doing. I think much of our engagement with them to access data and information would be in a formalized written setting, something in the vein of data requests to them. And then we'd be conducting our own calculations parallel to theirs to either demonstrate that we got the same answer or identify discrepancies and resolve them with them. I think between formalized processes like that and then documenting them clearly, that these are how we went about it and these are sort of separate, transparent calculations and validations, I think we could achieve exactly what you're touching on.
All right, thank you.
So in addition to specific work with securitization, we've also worked with utilities on bond issuance just in the normal course. Utilities that are managing their capital structures, utilities that are making investments and financing their business. In addition to the Empire securitization, we've called out here some securitization work we've done in Entergy in their Louisiana service territory. Those are interesting because there was a series of them. They were very successful, and here we actually brought some innovation to it. When staff worked with our team members worked with the legislature to get a law passed that would allow for the SPE, the special purpose entity that issues the bond, to be a tax-exempt government entity. So they were able to issue tax-advantaged bonds, and in so doing, save the customers a significant amount of money. We also do a lot of work on the rate-making side, which I think is important here. I know it's not necessarily within the purview of the advisor as to how to allocate the costs of securitization or how the rate design would work or how the surcharge will flow through. But there are elements of the legislation that require certification that costs and benefits to the surcharge itself are lowest possible. So I think it behooves the advisor to sort of have a deep understanding of how these things work. And this is something that we work on regularly. How is it that utilities can recover the costs of what I'll call unusual, sudden, or very volatile expenses like vegetation management or cybersecurity or things like that? It's an area where we have lots of expertise. And then last but not least, we've called out just a broad sort of selection of the kinds of proceedings that we do, that we've done recently. There's a weird color coding thing in our map here that was unintentional. I apologize for it. It doesn't mean anything. But I think it's fair to say that we cover sort of the entirety of the waterfront on the regulation of utilities. We regularly appear before regulators across the U.S. and Canada, and we testify on everything from cost of service to rate design to alternative regulation to transactions. So on the regulatory side, the rate-making side, the sort of regulated finance side, I think we have exceptional capabilities and a lot to offer. I'm going to hand this to Brad to talk through some of the more purely finance capabilities, unless there are questions on anything I've covered so far. Hearing none.
Thanks, Matt. Obviously, we have energy, we have finance. And from a financial market perspective, the one thing I want to emphasize is we talk about a securitization. What a securitization is in the basic level of fixed income is something that we do every day, but we have different assets and securities underlying it. In my career, I've probably securitized probably 20 to 30 different assets, and it could be as simple as a sales tax. It could be certainly energy charges that we have here. It could be a general obligation pledge. It could be revenues of the corporation. But that is a securitization, and that's what you do in fixed income day in, day out. My education went to the Air Force Academy undergrad. On graduation, I designed astrodynamic software at the Space Defense Center for all 5 years of my active duty commitment. And I've earned 2 MBAs, one in marketing emphasis and one in finance emphasis. As I mentioned earlier to the commissioner, I started my career at Merrill Lynch. I was recruited to head a capital markets group for infrastructure at Goldman Sachs. Did that for 10 years, and between Merrill Lynch and Goldman Sachs, that's where I mentioned I've been involved in over $100 billion worth of financings. And these are all securitized financings and a wide variety of securities. After Goldman Sachs, I was asked to run a trading company for them, and it became the leading wealth management trading company for fixed income, all varieties of bonds. We ended up, the investment banks that owned it ended up having over 100,000 registered reps on it and 50 broker dealers. So that was just fixed income day in, day out, looking at transactions. I've been at Charles River Associates for 10 years now. I took a 2-year sabbatical, which I call a sabbatical now. It was actually a 2-year appointment to be a senior advisor under the Trump administration to Secretary Mnuchin, to be Treasury's point person for Puerto Rico's bankruptcy. And it was time of Hurricane Maria, and wisely allocating their $40 billion of disaster relief funding. What I'd like to do is, let's move to the slides, and these are engagements that I'm typically involved in. There's a couple, I think there's 2 consulting assignments here, and we have 3 disputes. Disputes is our word for litigation. And my role in that is to write the expert opinion, provide the expert testimony, provide the, in the language we were talking about earlier, certification, quite often about bond pricing. And some of it is retrospective. Here's an example where MX Energy had a internal loan that they were seeking a tax deduction on. And I was the lead on this, where we were determining the true price of an internal loan. And it was a deeply subordinated, essentially unrated credit. And we had an earlier question about experience and pricing. It's actually more difficult to go backwards in time to see where that bond should have been priced. In this example, the courts have agreed with our opinion. Why don't we move to the next one? Which one? Which button is right there? Okay. Let me see. That one is. This is prior to joining Treasury, but I was actually asked to write the opinion on the sales tax bonds down in Puerto Rico. There was a suit there, and this is all very relevant because what happens when it kind of goes off the tracks? People argue about who actually owns security. In your case, obviously, the charge to the rate base. In this case, there was a dispute who actually owned the sales tax. Did the independent bankruptcy remote company corporation own it, or was it owned by the Commonwealth? And certainly no lack of myriad of issues and very high stakes, since it was $15 billion worth of outstanding securities. You asked about consultancy. I was involved with MISO, and that was, I think, one of the first FERC 1000 projects for transmission expansion. And the role I played there was both looking at, I think we had 15 finance plans to review to see the efficacy of the finance plans. And equally important, we looked at the creditworthiness of the people providing the proposals to MISO. And I mentioned I served 2 years as a senior advisor working on Puerto Rico. And what's germane to today's discussion is I authored the Treasury's analysis of PREPA. As you may know, PREPA is the utility down in Puerto Rico, which has had severe challenges. And we did the valuation, and that was the official document internal to Treasury in terms of our perspective on what should be done at PREPA and the $8.5 billion of defaulted bonds. And finally, just as an example of a myriad, no different from one you're looking at in terms of unique security and assets, the Air Force Academy was trying to build a visitor center, but there was no funding. And so a 50-year ground lease was granted by the Air Force to create a public-private partnership. And we ended up having probably about 10 different revenue streams, which are essentially asset streams. And I was the advisor, and this is probably most germane to being on the bond advisory team, which I did that quite frequently as a Merrill Lynch and Goldman Sachs banker. But this was advising the senior developer on the issuance of $350 million taxable bonds secured by just a wide myriad of credits from, ranging from lien on the lease to the various sales tax and various other taxes that were available on the property. So I'm going to turn it back over to Matt with that.
Thank you. As I think has been mentioned, we had also provided written responses to the questions. I'll just zip through them very quickly. And please do let me know if there's any follow-up to be had on any of them. Yes, we have reviewed the act. As to the second question here, our experience in the field, we have not certified securitization processes in the way that the advisor will, but we have executed securitization processes, which, for all the reasons that we talked about, we think is not only applicable, but we think preferable, but either way. We are able to provide the certification, or at least we expect to be, within 1 business day of the issuance advice letter. This is not the kind of process that should require a whole lot of last-minute calculations and late nights and panicked meetings. We would expect to be able to sort of keep up with the process almost in parallel off to the side as we're conducting our own validations and calculations, such that when the time came, the wide majority of what was needed for the certification letter would already be there on hand. And then why is your team best equipped? I think we covered that. We think it's the mix of our capabilities and our experience. There were a couple questions as well from the utility. No, we don't foresee any issues with the new disclosures. The second one, no, we don't foresee any issues from what we see in Kentucky and elsewhere. And yes, we certainly agree to be bound by any confidentiality provisions that may arise. So that's the end of our presentation. We're happy to answer any questions that any of the commissioners may have.
Well, thank you very much. Well done. Any commissioner questions? Commissioner Williams.
Thank you, Chair Powers, and welcome. We're glad to have you before us today. Mr. DeSorcy, with the Empire District Electric securitization, are you aware of what the impact was of savings that might have occurred to the company and its customers as a result of the process that you oversaw?
I don't know what the totals were, but I do know that the legislation was similar to South Carolina's legislation. It required that we demonstrate savings on a present value basis, and so we did get over that hurdle. I can't recall what the numerical savings were, though.
Okay. And I noticed in your proposal that 2 principals were listed, and I just wanted to make sure that if they had any work with the other Charles Rivers work that has taken place for DEC. I didn't ask that very eloquently, but Mr. Klein and Mr. Balashoff were in your proposal. Did they oversee any work that that Charles Rivers has done for DEC from your energy department?
No.
Okay. Thank you very much.
Thank you, Commissioner Williams. Any further commissioner questions? Hearing none, gentlemen, thank you very much for your presentation. We certainly hope to act on this in the next couple of weeks and get this thing going. We do certainly appreciate the fact that you went to the trouble of coming here and being here. Did Mr. Nagel need to say anything, or is he just...
I don't think so. Chris, anything to add?
Just one thing to add here. We do, as a firm, have a formalized firewall process. I know that the considerations about other work that might be ongoing and with procurement came up a few times. We have systems in place to make sure a firewall exists between all of the individuals that will be working on this engagement and in those procurement engagements.
Thank you very much. Sorry you couldn't make it. All right. Well, thank y'all very much. We will be in recess until the next participant.
Thank you.
Thank you.
We are back on the record as far as the hearing for Duke Energy Carolina LLC's application to securitize storm costs. We are here today for interviews to parties who have applied for this position. I would ask you, gentlemen, first, did you hear the earlier instructions? Were you listening in this morning at 10 o'clock? And if not, we're going to go through them again very quickly. Okay. All right. Mr. Westner Hill, if you would, please explain this procedure.
Yes, sir. Thank you, Mr. Chairman and Commissioners. As the chairman just referenced, the only item today on the special business meeting agenda of the commission is related to docket number 2025-65E and the public interviews of the individuals or companies that actually responded to the solicitation made by the commission. On May 22nd, 2025, the commission instructed its staff in commission order number 2025-316 to issue a request for proposal for the selection of a qualified independent third party as required by South Carolina law. The term qualified independent third party means a person or entity with relevant expertise in accounting, finance, or utility regulations sufficient to make the professional judgments necessary to certify compliance as required by South Carolina Code Section 58-27, 1110, subsection C6A. The qualified independent third party, or QTIP, shall be designated and retained by the Commission to participate in the pre-bond issuance review process established by the Commission pursuant to state law, as will be displayed in the Commission's financing order. The role and responsibilities of the QTIP are further detailed in section 58-27, 1110, subsection C6. The qualified independent third party's certification of compliance is intended to inform the Commission that the decisions and made with regard to securitization are in accordance with its financing order. On June 19, 2025, the Commission opened 5 proposals, including the one provided by you, Hilltop Securities, Inc. The other 4 were Atkins Capital Strategies, LLC, Charles River Associates, PFM Financial Advisors, LLC, and Sabre Partners, LLC. All of these were in response to the solicitation number 54000-28374. Mr. Chairman, the docket is ready to proceed to the next interview.
Thank you very much. Before we begin with the interviews, I want to remind everyone that a decision in this matter has not been made by the Commission in docket number 2025-65E, even though there was a settlement agreement presented by the parties of record. That record, of course, is closed, and would caution everyone from trying to obtain any indication through question or how a commissioner or commission would potentially vote. As Ms. Westner Hill stated, the purpose of these interviews is related to the 5 responses received by the Commission. By state law, the qualified independent third party designated by the Commission must act in accordance with the statutory obligations and additional requirements established by Commission order. The qualified independent third party must independently participate in the pre-bond issuance review process established by the Commission pursuant to Section 58-27-1110 C2J. The qualified independent third party has authority to request and receive all necessary documents, data, and information from the electrical utility to fulfill its responsibilities and ensure compliance with 58-27-1110 C6A, and has ability to communicate directly with the parties to the docket or the proceeding as needed by the qualified independent third party to carry out its duties. The qualified independent third party cannot communicate directly or indirectly with the Commission, any commissioners, or any member of the Commission staff. This is to prevent any ex parte communication which is prohibited by South Carolina Code Section 58-3-260. The qualified independent third party designated by the Commission must be able to work independently without involvement by the Commission or its staff, and be able to provide independently the conclusions as directed in the financing order and applicable law. The qualified independent third party is limited and can only communicate with the commission, the docket, through the commission's docket management system, DMS, with a file letter or document. Any other means is prohibited by law, including email, telephone calls, text, or any other method otherwise available to the parties. Excuse me. The commission and its staff cannot talk or communicate with you except through orders or filing provided to all parties. All parties must have the opportunity to be in any meeting or conference, and all parties must have the same communications intended for one and provided at the same time to all. Just like the electrical utilities and parties to this proceeding, the qualified independent third party makes any docket filing it believes necessary, subject to and in accordance with the Commission's procedural rules and orders. Third-party consultant may be subject to confidentiality agreements and prohibited from divulging sensitive information. Commission has a process whereby confidential information can be provided and protected from public disclosure. The qualified independent third party is subject to the same process as utility and parties whereby confidential information can be provided and protected from public disclosure. Commission may request that the qualified independent third party participate in a post-pricing meeting, which will include the electric utility, the qualified third party, and all other parties to the docket. Since I've explained and outlined the manner in which the qualified independent third party can communicate with the Commission and its staff, and that is only through communication filed in docket 2025-65E, there is no need to further address ex parte communications. I would like to welcome you all to here and would ask that you please introduce yourselves and tell us who will be presenting. You can tell us a little bit about yourselves, your backgrounds, if you like, before beginning with open statements and questions. I would remind you these proceedings are being recorded, so it'd be helpful for you to introduce yourself when you speak, and please speak up. Again, although we've received a settlement agreement, a decision has not been made, but that record is closed, so no discussion of our decision or order would be relevant or necessary this morning. I'm turning it over to you, gentlemen, and feel free to proceed as you wish.
Thank you, Mr. Chairman and the commissioners. On behalf of Hilltop Securities, I want to thank you for the opportunity to present to the Public Service Commission of South Carolina. As you will see in our presentation today, as well as in our written submission, we have a wealth of experience. We are a registered broker-dealer, financial advisor. We're well-equipped, both from an underwriting and secondary market trading activities to provide the necessary certifications required by the QTIP. To my far left is Michael Newman, Senior Managing Director. He will be the project lead. He has experience in Ohio, Oklahoma, as well as in current projects in North Carolina. To his, my immediate left is Chafin Snyder. Chafin runs our public power group, also has experience in North Carolina and some Oklahoma transactions. And to my immediate right is William DeSilva. William DeSilva is Vice President in our Charlotte, North Carolina office to provide local action as necessary. He has some experience in discussions, but has not executed a transaction. On the phone is our head underwriter, William Evans, Senior Managing Director, as a head underwriter of Hilltop Securities. My name is Mike Bartolana, Executive Managing Director, Co-Head of Public Finance. I've executed transactions back in 2007-8 for Texas, Ohio, Oklahoma, and now working on North Carolina. And with that, I'd like to turn it over to you for questions, if you should. If that's appropriate.
All right, and we have received your answers and the answers to the questions by the utility this morning. Also, I wanted to say, and I've overlooked this, thank you for traveling. I realize you're coming from all kind of directions, and we appreciate you being here live. Are there any commissioner questions at this time?
Mr. Chairman.
Commissioner Williams?
Thank you, Chair Powers. And I'll add my thanks for your being here and your interest. And it's a good opportunity for us to learn more as we do our service for the state of South Carolina. I wanted to ask about the work for the North Carolina Utilities Commission. Is it related to Duke Energy's Carolina, and is it related to Hurricane Helene?
We are privileged to represent the public staff of the North Carolina Public Utilities Commission in two matters concerning Duke Energy Progress and Duke Energy Carolinas. We represent the public staff.
And is this associated with Hurricane Helene?
Helene, as well as several other smaller events, yes.
Thank you.
You're welcome.
I may have other questions, but I'll
Sure.
pass it on to other colleagues.
Commissioner Cass.
Thank you. Good morning. Good afternoon. I noticed in, I guess, your proposal, the deep stuff, talked about Hilltop Securities was formed from a merger, I think, of Southwest Securities and First Southwest Company, LLC. Is that correct?
That's correct.
And while that merger occurred in 2016, if I understood that correctly, it said Southwest, and I guess First Southwest had over 70 years of
That's correct.
experience in financial services. Were those financial services, I guess, comparable or, I guess, along the lines of what we're doing here?
Yes. Absolutely, yes, sir. First Southwest Company was formed in 1946. I was vice chairman of the firm until 2015 when the merger occurred. First Southwest Company advised on CenterPoint, Entergy, AEP, and First Energy transaction. I personally led those transactions with our team, so that experience carries through to today.
So I'm assuming that the folks from Southwest and First Southwest, those that have not retired or moved on or part of.
They're part of this team, yes, sir. So Mr. Newman was at First Southwest, new to the team members. Mr. Evans, our underwriter, Mr. DeSilva, and Chafin joined our firm within the last 4 or 5 years. As a point of note, in 2015, I left to take a little sabbatical, 4.5 years roughly, running Citigroup's public finance regions around the country. And then I came back post-merger into my current position as co-head of public finance.
And you probably said this, but all of you from Charlotte or some from Texas, all of you from Texas? Or?
Charlotte, Texas, New York, and Raleigh, North Carolina.
And speaking of Texas, I know it's been quite a tragedy.
It's been a rough
this
week
weekend.
for Texas.
So
Thank you.
we've not forgotten Texas.
I appreciate that. Thank you.
I guess finally, kind of circling back to the question Carolee Williams asked, Commissioner Williams, thinking about your work you're doing for the North Carolina public staff, what sort of impact would that have on this process, you think?
One of the things we think we offer the commission as a firm is a bench. There are three of us equally knowledgeable of utility securitization. Chafin worked on the securitizations by LIPA, Long Island Power Authority. Mike, as he mentioned, worked on Texas, Ohio, and he and I worked together in Oklahoma. We feel we have the bandwidth to provide appropriate service to both entities, and we see a value to representing both entities because they're supposed to come to market, the securitizations, at approximately the same time. So no other advisory firm will have the insight into investors active at that time as we will, because we will have seen, at this point, I believe North Carolina transactions are expected to come several weeks in advance of South Carolina. No other advisory firm will have that insight into who is active from the buy side in these type of securities. We will bring a common reference to the most recently completed transaction to the discussions as part of the bond advisory team and share a common base of knowledge with Duke and others that may have participated in North Carolina transactions. And I think one thing that's we hope resonates is we were asked in our proposal for references. One of the references we provided was the Executive Director of the Public Staff of North Carolina, and would encourage you to speak with them to ascertain not only our knowledge, but how we approach things and conduct ourselves as individuals and as a firm.
I'd like to add to that. What we bring to the table is a full-service fixed income investment banking firm, primarily municipals, but also in asset-backed securities. So you have the benefit of active participants in the market acting in a fiduciary capacity as your qualified independent third party. We're able to assess the market. We've traded last year about $19 billion of corporate securities. So at the end of the day, we're not relying on indexes. We're not relying on third party information, innuendo, whatever the market is quoting. We're actually in the market. And I think that's an important distinction from a lot of our competitors that were mentioned earlier. It's that we bring the capacity. We have over 200 people in public finance at Hilltop Securities. So we could bring a lot of effort to bear on a transaction. We have 5 underwriters. We have 10 taxable secondary market traders. So we're well equipped to understand the market and present ideas and challenges to the underwriters that are selected in order to get to the regulatory requirement of the lowest price cost effectiveness.
Last question. Just thinking about it, 200 people. I know with the internet and with all the technology we have today, whether you're in Texas, Kalamazoo, Charlotte, probably not very relevant. But that said, how many folks do you have in Charlotte?
Approximately 15 people, I would say. And I'll just assure you, I think my second address is 30,000 feet mid-continent. I'm on a plane. I'm here to serve customers, just not manage a business and make sure you have the right resources at the right time to execute your transactions.
All right. Thank you, gentlemen.
Thank you. Commissioner Williams?
Okay. Thank you, Chair Powers. I thought I might come back with another question. This one is related to the certifications that you'll offer, and I know you answered these questions in your submittal to us this morning, but I wondered if you had, one of the answers was just a little bit unclear to me. Have you been able to offer certifications without any material qualifications?
When you say material qualifications, when we look at, we try to describe a transaction. What is unique about the transaction? Every transaction is unique, whether it's tenure, it's obviously we strive for a AAA rating in these transactions, but market conditions, what's competing for you out there, we'll describe that. But at the end of the day, we'll tell you that in our opinion, that it will meet the requirements of the lowest cost at that time for this type of transaction. A lot of people, when I look at transactions, will take snippets of markets. They'll take a secondary trade here, a secondary trade here. When you're selling $550+ million worth of securities, according to the settlement agreement, roughly, you have to look at the totality of the underwriting. And so we look at that and we can offer that. We know what it takes to underwrite all the securities, to purchase and sell the securities. Yes, the securities will be subscribed for, but there is a process that starts 2 or 3 weeks out, and we're involved in that process. And being part of that process on a day-to-day basis allows us to get to the opinion I think that is required by state law.
Thank you. I'm looking at your answer to Duke Energy Carolinas, was their 4th question. Has your firm ever declined to provide a certification? And you all say you've not declined. have you been in circumstances where you have certified with material qualifications?
Not to my recollection. I would say in this space, we have not declined. We have declined, in my recollection, probably 30 years ago, a transaction where an issuer, it was a school transaction in another state where an issuer priced a transaction with the investment banking firm without knowledge. They just put it in the market and told us, here's the price, and we said we're not going to participate in that. We have certain standards that we're going to comply with. If we have proper notice, we're involved in all the conversations. We have not declined. But when people do stuff away from us, we're not going to just rubber stamp a transaction.
Understood. And maybe I didn't ask that correctly, because it's clear to me from your answer that you've not declined, but where you have offered this certification, have you done so with material qualifications? Are there certain circumstances where you had to offer, you could only offer the certification with material qualifications?
Not to my recollection. I don't think so. No.
Okay.
I mean, it depends what the lawyers write, right? I mean, we're going to be, but a standard, this is, in our opinion, this is the lowest price to clear the transaction in this market at this time. Yes, we can, that's what we strive for.
Thank you. And mentioning lowest price, would you all go into some detail about how you are confident that what you have achieved is ultimately going to be the lowest price for the customer, for the company, and for us?
So we start with a process that really starts 2 to 3 weeks before the actual marketing of the bonds. It starts with pre-marketing. It starts with surveying the market, talking to the underwriters, talking to our desk. We have 2 desks. We have a securitized product desk, and we have Bill Evans on the underwriting desk. And underwriting is different than buying a secondary market transaction of just a specific security. You're buying a portfolio of securities here that have to be purchased all at one time at a specific dollar price. It's usually close to par, just a little bit below par. So we go through a process of, as Mr. Newman alluded to earlier, is what transactions have occurred recently in this space. What's unique about this space today is it's a AAA rated space, right? You used to have U.S. Treasuries. They're no longer all AAA rated. We've lost that recently thanks to Moody's. But at the end of the day, we understand who's buying these securities. These securities usually don't trade frequently. They may trade a little bit right after the initial underwriting period or shortly thereafter. But we go through so we have an inventory of what transactions we actually participated in as underwriter. Who's the investor? We know what transactions we've been advisor on and who those investors are. We will challenge the underwriter to make sure all the names that we know that are active participants in that market have been touched, that we have the feedback from those investors. What do they like and dislike about this transaction prior to launching the transaction? So I think that's really important. You have good legislation that allows you to have non-impairment, non-bypassability. So we expect the AAA rating. So I think that's important. But it's also important is there something in the transaction they don't like? What is the service area description? That needs to be addressed and understand that before we proceed forward. So prior to announcing a transaction, we will have a pretty good pre-market discussions with the underwriters as well as the company to understand where the market is, and we'll give them the feedback of where we see who's buying the securities in the secondary, what recent underwriting transactions have been done that are similar to this, and what we think could be appealing in other markets. As you know, there's some controversy over the ABS versus the corporate market. We will try to push them as not only market into the ABS market, but also to market into the corporate market. So you have the benefit of both markets. Michael Chafin, did I miss anything?
The only thing I would add, we would push all markets, including taxable and municipal securities. The idea is simply the amount of debt to be issued would be set by the settlement agreement if accepted by the commissioners. The greater the demand, the lower the rates are driven. From our perspective, we are agnostic as to the sector the investor comes from. Our goal is to see that all investors that may have potential interest are aware of the transaction and have the opportunity to participate. we view all entities, whether it's the utility or the commission, the underwriter, it's in everyone's best interest to secure the lowest cost. There has been discussions and testimony about underwriters and their motivations. It is a repeat business, and we have seen instances where underwriters that were not aggressive were not rehired, and that's the way it should be. A utility has an interest in keeping the charge as low as possible. When the rating agencies look at these bonds, they don't look just at the charge to repay this specific issue. They look at the totality of charges for this purpose. So to keep it lower provides flexibility for the utility. God forbid they need to issue this type of debt again because there's been calamitous events. They have that ability. It is in everybody's best interest, we would argue, to keep that charge as low as possible. The ratepayers, obviously, it keeps more money in their homes and their pockets. And two of us here have family in South Carolina, so we have a personal vested interest in seeing that charge is kept as low as possible.
And part of our job, as I said earlier, is to provide a constructive attention, to push the underwriter, to ask questions, to probe, but also to be accretive to the transaction and not be an obstacle to getting a transaction done. Sometimes you have to take advantage of certain markets, and understanding that markets are moving, volatility, there's a lot of things happening in the world today, geopolitical events, our economy. There's a lot of things that go into pricing a transaction at any point in time. And sometimes you got to take a look at the greater good versus a specific event price.
And I think that the other thing that kind of sets us apart and helps us to be able to say that you got the lowest possible cost on the day of the pricing is the fact that, we are a broker dealer. We do have a desk. We are out in the market putting our capital at risk. We're having the conversations with investors on a daily basis. It gets back to, we're a market participant, not a market observer, and therefore we're able to have, leverage the benefit of other transactions that we're involved in, both in the primary market and the secondary market, to have that real, finger on the pulse of what's happening in the market and to be able to give you those certifications and the comfort that on the day of pricing that, we're able to make those certifications with respect to, lowest cost of funds.
We're not relying on third-party information from other broker-dealers to help inform our opinion of what price is. I think that's important. If you're not a market participant, how do you know what price is? You observe either historical secondary market transactions, you look at indexes, you look at what current offerings are in the market of large transactions. That's difficult to do if you're not a participant in the market. And a lot of people say they can do it, but we're not calling other broker-dealers for what is the price talk on a transaction. I think that's differentiates us.
Bill Evans, do you care to comment as head of our underwriting desk and the person closest to the market?
Yeah, sure. Thanks, Mike. Am I coming across?
Yes, you are.
Well,
Okay, great. Yeah, just to add on, I think all of that was very important, how we looked at deals. I will be that point person on the deal if selected, whereas I'll be conversing with the underwriter who's pricing this deal. But also, as Chafin mentioned, I am deeply involved in the marketplace every single day, whether it's other municipal advisory transactions, negotiate underwritings that we are leading, or competitive underwritings that we are bidding on. So we are entrenched in the marketplace, seeing a ton of a variety of different deals by all different issuers in this space. We also have a full service taxable desk, ABS trader, MBS trader that we also bounce ideas off of and get feedback from them. There's going to be very other people in this marketplace that can offer what we can as a municipal advisor that has the access to the marketplace as we do. And one of the things that I'd like to mention that I think Mike Newman and Mike Bartolotta both did is we have the knowledge in this space, and anecdotally what I can say is if you go back to 2022 where we did the Oklahoma deals, it was a 4-series deal. As was mentioned, we know who the buyers are of these transactions. We see the price progression of these transactions because we were the municipal advisor on these transactions. So just as I mentioned before, anecdotally, when we got to, I think it was the 3rd or 4th transaction, and the underwriter came to us and said, we think we need to be a little bit cheaper on this one. We said, well, what buyers have you talked to? And they listed somewhere in the neighborhood of about 10 buyers. We know for a fact, because we were involved on the other deals, that underwriter was not, that there was upwards of 80 or 90 different buyers in a transaction. Coming to us and saying that we have feedback from 10 buyers, when we know that the marketplace is a multitude of buyers more than that, is not sufficient to us. We had that information. We made sure that underwriter went back and got us more sufficient information. And as we worked through the deal, we actually got a better pricing because of it. Because we held their feet to the fire, because we knew what happened on the previous deals, we were able to push them and say to them, you need to go back and do better for us. This is not right. And that's exactly what happened. We knew who the buyers were. We knew the pricing progression. But because we had that information on prior transactions, we were able to do that going forward onto that third or fourth one. I forget which one it was in that series. And then moving forward into, I think, March of 23, we were a co-senior manager or joint senior manager on the Texas deal, Texas securitization deal, $3+ billion deal. And again, we were able to be extremely value added there. We acted as underwriter in that transaction, but because we had this knowledge base in the marketplace, again, we were able to push pricing a little bit for the syndicate as we entered into that pricing. So the knowledge base of being in here, the knowledge base of being part of the marketplace and not just an observer of the marketplace, really is a direct benefit to those we serve as municipal advisor for.
Thank you. Mr. Evans, did I get your name right? Okay.
That's correct. Yes.
Well, my last question is, given what you've said, you all would be conflicted out in terms of your participating in this offering.
That's
correct?
We would put it on a restricted list. We have policies and procedures, but once we're a fiduciary, we're not in an underwriting capacity.
Thank you very much. I appreciate it.
If I may, just as Mike alluded to, there's provision the QTIP in the legislation cannot benefit or have an interest. We cannot underwrite a transaction for which we serve as financial advisor, as Mike said. And as Mike alluded to, we would put these bonds on a restricted list so no person in our firm would trade these bonds, so we would be in compliance with the legislation.
Thank you.
Thank you, Commissioner Williams. Commissioner Thomas, do you have any questions?
I did, but the question I was going to ask was just covered in the conversation. So
thank you.
No,
We'll
I do
move
not.
on down the line to Vice Chair Williams.
Thank you, Mr. Chair. Thank you, gentlemen, for being here. I want to take what you all just said and translate it into my terms, just to make sure I'm understanding what you're saying. It seems to me that there's a certain level of confidence that your organization has in the ability to ensure that ratepayers get the, anecdotally speaking, the best deal from this transaction, and that stems from your experience as underwriters in the market. Is that fair to say?
Yes, sir. That is correct.
So if I'm comparing and contrasting your organization to your competitors, what I'm hearing is that you actually have boots on the ground in this environment, separate and apart from participating in securitization.
That's correct. Okay. We price on average, either as MA, underwriter, placement agent, approximately 18 transactions a week. Bill, is that's a pretty close number, right? It's actually picked up a little bit recently.
Yeah, that number's about right, that we're actually can point to and involved in. There's a whole subset of deals, though, that we're actually looking at, involved in, and having conversations with buy-side customers that it's called competitive bidding. We may not even buy that transaction, but we gain a ton of knowledge from the marketplace. And because of that, where we sit, that knowledge is based on communication with buy-side customers that'll be buying your bonds when you do come to market. And a lot of our competitors do not sit in that space where they can have that conversation.
And that's about another 10 to 20 transactions on average a week. So in addition to what we actually execute on, we have a wealth of knowledge. We're in the market. We're talking to the tier 1, 2, and 3 investors all the time.
Thank you, gentlemen, for that. And based on that experience, it also seems like there may be an art to working with the utility or working with the underwriter to ensure that you can push back, if you will, in a way that doesn't create unnecessary tension.
Yes. I mean, for example, hypothetically, say the market doesn't want to buy 7-year bonds, but wants to buy 5-year bonds. And we were able to carve a 5-year tranche out and then move the 6 and 7 years into a later tranche that investors are willing to buy. That is helpful to the transaction. That's being constructive. That's saying, this is what the market is willing to purchase. Let's structure a transaction that they're willing to pay for. Let's not structure a transaction that we're going to throw out there and we're going to have to push uphill to get it done. So that's part of the conversation that happens 2-3 weeks before. We'll look at the numbers. We have Steve Johnson to help us modeling the numbers, Arthur Staub. So we have modeling capabilities. We're going to come at this as if we were the underwriter, but we represent the citizens and the Public Utility Commission.
And to that point, I think to add further on to that, we're all going to be part of your deal team. We want everyone to be successful. We want the underwriter to be successful, but we represent you. We're going to make sure that that is followed through. It's not an adversarial relationship. It's to make sure that the whole team is rowing in the same direction, that we know what the goals are of the transaction. We make sure we hold the underwriter to their capabilities to make sure that they can deliver on those goals.
And I think, as Bill said, it's holding, you can say holding their feet to the fire or being additive to the process, bringing up investor names that we haven't heard having been consulted. When Bill and his colleagues on our underwriting desk talk about spreads to the benchmark treasury that these bonds are priced off of, they're referencing actively traded securities in the market. They are not using models, they are using trades. And the underwriters that they speak with know that Bill and his colleagues bid competitive issues. They underwrite bonds, and they know that we are looking at the exact same information they are. And what we typically say is we will not ask someone to do what we are not willing to do ourselves. Conversely, if we were willing to do it as an underwriter, we expect that underwriter to do so as well for the benefit of our client.
I would also say not everyone has all the knowledge. So having an open, constructive dialogue is important to the process, because they may see something we don't see, and they'll say, hey, Mike, did you think of this? Or we look at economic numbers that come out. The world is a very technical space today with lots of information out there. What happens overnight may affect us. Do we postpone pricing? Where do we see it going? So it needs to be collaborative, but it needs to also have the right amount of attention to make sure that we can get to where we can certify that we feel comfortable with put our name on it's the lowest price.
I would argue it is not about us. It is not about the underwriter. It's actually not about the commission. It's about the ratepayer. And that is the guiding principle that we're going to follow. And ask the underwriter, is this the best you can do for the ratepayer? Because that's what we are all there to serve. And that's the purpose of the issue in the first place, is to reduce the cost. You have to have a quantifiable benefit to go forward with the issue. That's why this is all being done, for the benefit of the ratepayer. And that should be the guiding principle of all parties involved.
Thank you, gentlemen. Mr. Chair, that's all I have.
Thank you, Vice Chair. Any further commissioner questions? Commissioner Thomas.
Thank you, sir. So in your original handout materials, you mentioned the negotiated sale and how Hilltop Securities would be involved in a negotiated sale. I'd just like to hear a little bit more about that process and anything you have to say about that.
First of all, we start as being an active member of the bond working group, working with the company, the selected underwriters, the council, to make sure we understand the documents, understanding the financing order, understanding the registration statement, and so forth is really important. So that's the first place we start. And then from there, we start doing some research. All things start with research. And start talking to people within the firm. Hey, this is what we're looking at on transactions. We're not giving up the name of the transaction, but we're looking for, is it a different size? Who's coming to market? What day of the week they may be coming to market? What's their structure that would potentially look like? What has been announced? Look at the forward calendar. That's really important to understand what the economic calendar is and what the market calendar is, and what markets, as Mr. Newman said earlier, that we could push this into. And then we go through day-to-day transaction that Mr. Newman and Mr. Snyder, very adept, and I'll also be on a lot of phone calls, covering every working group call to make sure we're on the call, making sure we know what was discussed. We discuss it amongst ourselves all the time, translate that to our underwriting desk to make sure they understand what the structure looks like. So then once we understand what structure is, then now is that a sellable security, package of securities? What is the market that we're trying to sell into? What is the timing? What are we competing against? Did I miss anything, gentlemen?
The one thing I'd add, one of the things we talk about consistently, is, especially in the last 18 months with the volatility in the market, is flexibility. What can we do to improve flexibility for our issuer to avoid a day when things go badly versus bring something forward on a good day? And we recently participated in interviews of underwriters related to these type of bonds, and we asked every underwriter that question. Given the volatility that's being experienced in the capital markets for the last year, especially since Liberation Day, what steps can be taken to afford the transaction greater flexibility to avoid a bad day, as well as take advantage of a good day? We know what is on the calendar. We have the economic release dates calendared, but it's the things we don't know. What flexibility can we build into the transaction timing for the benefit of the ratepayers to avoid a bad day just because it's a bad day?
Yeah, and also understand that this is an episodic market. Within the last 2 years, about $5.5 billion worth of securities, the top 10 transactions. 10 transactions. It's not a lot of transactions. So you got to know what's out there. The good news is that these securities usually don't trade because of the nature of the pledge, the nature of the rating, the stability of the rating, the true-up mechanism. Understanding all those things, where do people go with these transactions? They go put them and people are willing to pay, making sure that there's room on the calendar, and that's once it's announced, that people have enough time to say, I'm going to do my credit work as an investor to qualify this so I can make it, submit a purchase through my portfolio manager. So so having enough time for credit to be done at the investor, having that dialogue and that feedback from the underwriter to the rest of the working group, and making sure that we're dialed in to have a transaction that is successful.
All right. Thank you. I appreciate that.
You're welcome.
Thank you, Commissioner Thomas. Any further commissioner questions? Just a couple of things, gentlemen. The credentials that you entered today, I can't help but notice it says on there confidential and proprietary. Is there something in there now that needs to be marked confidential or held back?
Not on this. Proprietary, maybe. You know, we just don't like people copying our materials.
All right. So, and my other thing is, with your representation of the North Carolina staff, do you see any conflict or possible problem with that? Because we're dealing with the same companies that they deal with, same players, same characters.
No, we don't see a problem with it. We actually see that as potentially being helpful. I think they're further advanced than you are, and then you're going to give some good secondary market color and execution on where that transaction happened. So you have a good, close reference point with the company that's on point. So I think that's should be helpful.
All right. So, well, thank you very much. Nothing further from the commission. Gentlemen, thank you very much. Thank you very much for traveling. And it means a lot to have you here in person and see who we're dealing with, and made a very good presentation. We hope to act on this within the next couple of weeks. We're hoping to move as fast as possible on a lot of this, both in the decision making on the proposed settlement, and I think we have our next one at 2:00, but that's it, and thank you again.
And I want to say thank you for the opportunity on behalf of my partners at Hilltop Securities, and thank you for the kind words, Commissioner Caston. Regarding Texas, I know it's also a tough time that South Carolinians had with these storms also. I mean, it's trying times, trying world. both economically and with weather events. So, we're here to hopefully be a positive attribute to your transaction. Thank you for the opportunity.
Well, thank you. Very kind words. Thank you. We are in recess until 2 o'clock.